Hi, everybody, and welcome to our continuing coverage of the People versus Richard Allen, Delphi Unhinged. And it's just me tonight because now Bob is on his annual boys' trip for the Super Bowl. They don't go to the Super Bowl, but they go to a location where they celebrate all things Super Bowl. So we're here today with some recent filings in the Richard Allen case. We have already went over the defense's motion to correct errors, and what we have now is the state's response. We also have a motion from NBC to intervene, complaining about not getting discovery. So I don't know. I guess my question would be, which should we do first? There'll be a lot less to talk about on NBC's motion, but all right, I'm just going to start with the state's response because I'm sure that is what is most interesting. A lot of the state's response is, somewhat as predicted. And I guess some of you will have to tell me if there's some new information in here because I don't have Bob who knows all things Delphi better than I do. But so here's the petition or their response, the state's response. It's the state's response to the motion to correct errors. So now comes the state of Indiana, the prosecuting attorney. They're filing their response. They want it to be denied. The court's motion, the defendant's motion does not warrant a motion to correct error because a motion for safekeeping filed by the Carroll County Sheriff is not a critical stage of the proceedings, and the evidence concerning Brad Weber, Ron Logan, Stacey Eldridge is not newly discovered evidence to warrant a new trial. The state would ask the court to consider the following. So the state goes on to indicate that with regard to the safekeeping order and the 6th and 14th Amendments, they restate the defendant's claim. The defendant claims that his 6th and 14th Amendment were violated because he was deprived counsel at a safekeeping proceeding November 3rd, 2022. And that proceeding was a critical stage where he was not entitled to an attorney. I'm sorry, where he was entitled to an attorney. This is the defendant's claim. The defendant further claims that since he did not have counsel at that hearing, the conviction should be overturned. They cite an Indiana statute and state that upon motion by the sheriff alleging that an inmate in a county jail awaiting trial is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, the court shall determine whether the inmate is in imminent danger of serious bodily injury or death or represents a substantial threat to the safety of others. If the court finds the inmate is in danger of serious bodily injury or death or represents a substantial threat to the safety of others, it shall order the sheriff to transfer the inmate to another county jail or to a facility of the Department of Corrections. The statute does not require the court to have a hearing to make this determination. The court can make this determination based on the motion alone. And I highlight that just to note there's no citation there to any support for this proposition, although the state does get into case law to support their propositions later. We'll see. I don't recall this one being addressed directly. The state goes on to say that the defendant in this case was taken into custody on October 26, 2022, and housed at the Carroll County Jail. That initial hearing was held on October 28, 2022, where the defendant entered a plea of not guilty. The court advised the defendant of his right to counsel, and the defendant notified the court that he would hire his own counsel. He at no time stated that he had counsel. And then they cite the order attached as Exhibit 1. I don't think that him saying he's going to hire his own counsel in response to being told that he's got the right to have counsel appointed circumvents the fact that the state and the police all knew that he actually had counsel. going on, the state points out that after the initial hearing, the defendant was moved to White County Jail due to overcrowding at the Carroll County Jail. He was not moved to the White County Jail due to any safekeeping order. Now, I highlight that because I'm wondering, is that something that has been disclosed before? Was that always the state's position, that that initial move was due to overcrowding at the county, at the Carroll County Jail? And I'm going to stand by to see what do you guys say on that. Meanwhile, I'll thank Deja Vu for becoming a YouTube member. Thank you. Thank you. Andy says it's nowhere. Never. Okay. Michael Osbrook. Not that I don't trust everybody else who's commenting, but at least I know that Michael knows, is familiar with obviously all these orders. And that was going to be my next question. Are they allowed to willy-nilly just say, well, no, we did this for overcrowding and there's no procedure that needs to be followed. There's no, not even necessarily due process, but something that has to be established in order to make that move. And Michael's saying you still need a safekeeping order. So there's that. All right. That on November 2nd, 2022, the Carroll County Sheriff, Toby Leesenby, filed a request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections for safekeeping, commonly referred to as a motion for safekeeping, and that's Exhibit 2. Now, this is interesting that on November 3rd, 2022, the state received an email from attorney Brett Gibson stating that he would not be representing the defendant herein. And that was sent at 9:58 a.m. So I wonder if Michael knows what time this hearing was held, or the court considered this issue on November 3rd. Was it before or after that email was sent? And then I'll flip over here, and mods, if you see Michael responds, put it up there and I'll click back over. That on November 3rd, 2022, and again, I'm just highlighting this because I'm wondering the time frame, the court granted the sheriff's motion without hearing and determined that the defendant was in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others, not based on any acts or alleged acts by the defendant, but by the insistence on public information, noting that it is extremely dangerous and put all public servants in a dangerous situation without any reasoning as to why, I guess. That in this order, the court noted that the defendant intended on hiring private counsel, further supporting that no attorney had entered their appearance of counsel of record for the defendant. Again, that's just bullshit. Everybody knew. And the way the defendant himself words it, and whether that means that they're allowed to take it to understand that there is no attorney when they know, in fact, there is an attorney, I don't think that they're winning based on that position. That a safekeeping motion is not considered a critical stage of the proceedings. And they're going to get to some law later. We'll see if they actually establish that or not. But they go on to say where the defendant is required to be so it's not a critical stage of the proceeding where the defendant is required to be present with counsel. That the sheriff has standing to file a motion for safekeeping because although the defendant was moved to White County Jail, he was a Carroll County defendant. He was only moved to White County Jail because the Carroll County Jail did not have sufficient room to house him in a cell by himself as evidenced by the affidavit of Toby Leesenby here and attached as Exhibit 5. Again, I find it odd that this is not something that they've ever mentioned before, not a position they put forward before. And you're talking about the authority of two different people here. One, where the defendant is, where Allen is a defendant is different than who is the sheriff for the purposes of the safekeeping motion. Who is the appropriate sheriff? What jail is he in? So I'm not sure that this solves the issue. It's like the state's answering a question that wasn't necessarily asked. They're talking about the sheriff having standing because the defendant's court case is pending in Carroll County, but we're talking about which sheriff has the authority to make a safekeeping request for a safekeeping order. That Judge Diener was presiding judge over the case at the time and therefore had jurisdiction over the case, and further was within the jurisdiction of the appropriate Indiana statute to make a ruling on the motion without a hearing. So again, that's going back to the authority that a judge has and the jurisdiction that a judge has, not the authority that the sheriff had to make the request in the first place. They go on to say that the Indiana statute does not allow a defendant to request, does allow the defendant to request a post-transfer hearing, which is what occurred in this case. The defendant requested a hearing on the safekeeping order, and one was held on June 15th, 2023. Now, this, I think, maybe does touch directly on the issue raised in that it shows that he had the ability, some due process was afforded to him, at least the opportunity to have due process was afforded to him. And whose fault is it that the judge ultimately found it wasn't even, worth a hearing? He still had access to the courts while he was represented by counsel. Again, I'd be interested to see what Michael has to say about this. And since Mandy didn't highlight any of Michael's other comments, let me just see if he commented on this. All right, let's see. So Michael's pointing out that, hey, Nick McClellan hadn't filed his appearance and he was at the initial hearing. Again, that goes to the fact that I think it's clear that everybody knew, and they're trying to kind of skate away from that. I don't think that's going to work. And we will get to the fact that there was nothing about the joint drafting. I think in here somewhere they deny that the judge helped at all, and we'll look at that in the affidavit. All right, so let's go on, and you know, I want to just point out that part of what the point is here, and I guess I'm speaking for Michael at this point, but is and the defense, but is to get information into the record so that the court can consider it on appeal, new evidence that wasn't on the record already. And we'll get to that with some of the additional issues. So, even if the judge denies this without a hearing, it's laying the groundwork for things to be considered on the appeal. So the state goes on to say that at the June 15th, 2023 hearing, the court found that the defense's allegations were untruthful and not well-founded, and denied the motion to modify the safekeeping order. Now, obviously, we had and continue to have issues with the judge's determination that the allegations were untruthful and not well-founded, and it seems that evidence that was admitted at trial shows that she was wrong about that. Um, but again, her ruling is different than him being denied access to the courts while represented by counsel on these issues. Although ultimately he was never afforded the opportunity to be heard um, on the issues at the end of the day. And then that begs the question is that, as a result of another error by the judge in this case in making that finding and not even uh, and later not even allowing a hearing. The state goes on to say the court further found that the safekeeping order was reasonable and necessary to ensure the defendant's safety and to prevent serious bodily injury to himself, thereby affirming the court's order of November 3rd, 2022. Therefore, the defendant had a right to object and exercise that right, and his counsel failed to show the court that the safekeeping order was unnecessary. In fact, the court found that the defense not only did not meet their burden, but that the evidence presented at the hearing did not support the allegations advanced by defense counsel. So again, on that issue for me, it's more about the mere access to courts on this issue with counsel. And again, ultimately it was denied, and that raises a almost separate issue of whether the court did that correct. But, you know, to still stand and say that the defense didn't meet its burden, and they couldn't support the allegations when we know much more, now, or more shows that it was not unsupported and that they were not just talking out of their ass. The state goes on to say the defense filed an additional verified motion for immediate transfer of custody on September 18th, 2023, which the court denied without a hearing. That the defendant's due process rights and constitutional rights were protected throughout the course of the case. So I'm trying to convey here that the primary issue was the defendant was denied counsel at a critical stage. He was, denied due process, and this was never rectified. And I think the state might have a point that the fact that defendant had an opportunity later and did present the issues to the court later with the assistance of counsel is something, but then you have the flip side of that where the judge erroneously, if the defense can show, erroneously ruled on the issue, and then even later erroneously denied a hearing when there could have been substantial new evidence presented at that hearing that wasn't available um, at the earlier hearings. So the state goes on to say that under both the Sixth Amendment of the United States Constitution, Article 1, Section 13 of the Indiana Constitution, the right to counsel only applies to critical stages of the prosecution where the absence of counsel might derogate from the accused right to a fair trial. Further, a stage of the proceeding is only critical if it is one where incrimination may occur, or, and this is the important part, or where the opportunity for effective defense must be seized or foregone. And yeah, was it forever foregone? Possibly not. But at the end of the day, yes, because the judge didn't even grant a hearing at the second time the issue was raised. State goes on to say the right to counsel is not generalized protection for all purposes. It is not the right that is implicated just because a question of law may arise. The motion for safekeeping Safekeeping does not touch on matters of guilt or impact the ability to have a fair trial. It is a mechanism for housing the defendant in a penal facility pending trial that will keep him and others safe. The defendant is not facing the advocacy of the prosecutor with respect to his guilt or innocence of the charges. It is further not a stage where incrimination may occur or where the opportunity to present a defense to a charge must be seized or forever lost or impaired. So, which is a little bit different language than we saw up here, which it says it's critical if it's one where incrimination may occur or where the opportunity for effective defense must be seized or foregone, which, you know, um, effective defense means different things in the law when you're talking about different um, aspects of the proceedings. It's not necessarily the defense that you put forward. But part of what the defense has pointed out here is that he this did lead to him losing the opportunity um, to present his full defense uh, or affected him throughout the trial because obviously of the mental health issues that followed and then the so-called confessions. So the state went on to say, so it is further not a stage where incrimination may occur or where the opportunity to present a defense to the charge must be seized or forever lost or impaired. It has been found that the filing of an information is not a critical stage. The probable cause hearing or initial hearing are not critical stages, nor is the procedure to select a special judge. The state proffers from that it is safe to surmise that given those rulings, a motion that does not even require a hearing would not be a critical stage in the proceedings, which in turn would not entitle the defendant to a new trial. Again, the facts here are somewhat different, although typically, a safekeeping motion may never touch on matters of guilt or impact the ability to have a fair trial, may very well be just a mechanism for housing the defendant in a penal facility. But we know here it went beyond that. And we'll have to wait and see, assuming that the judge is not going to do anything with this at this level, how the higher courts consider this under the facts presented in this case. That since this was not a critical stage of the proceeding, the defendant did not have a Sixth Amendment right to counsel, so he was not denied the Sixth Amendment right to counsel. That even if it was determined to be a critical stage in the proceeding, any Sixth Amendment right to counsel would be reviewable under the harmless error analysis. Now, I did some research here, but I did not get a chance uh, to look at chronic based on this assertion by the prosecution. So maybe Michael can chime in. Um, the defense cite United States v. Chronic as precedent to overturn the conviction, but they do so because they misunderstand the case. The defense believes that the case says that a harmless error analysis is precluded because the defendant was denied counsel at a critical stage. However, the case states that the Sixth Amendment violations raise two questions: whether a Sixth Amendment violation has occurred and whether a constitutional violation was harmless. Prejudice must be an element of a constitutional violation to warrant reversal. In Chronic, the issue was ineffective assistance of counsel, not a lack of representation at a critical stage. In determining if not having an attorney at a critical stage reaches the level of a violation, the harmless error analysis is used. Now, they don't cite any case law there. They don't say that's the case. And I think that the prosecution is misunderstanding Chronic, because if the court's saying that there's no harmless error analysis when a defendant is denied counsel at a critical stage, how, if now, because again, this is the state saying, assume this was a critical stage. Now the state's saying that ineffective assistance of counsel at a critical stage might not allow for a harmless error test, but the complete denial, having no attorney at a critical stage, is subject to a harmless error analysis. I'm going to come back in here and see, give Michael a chance to chime in about his misunderstanding of chronic here. All right, Manny and Tracy, keep an eye out to see if Michael chimes in on that issue. The state goes on to say that the lack of a hearing for a safekeeping motion on November 3rd, 2022, and the lack of counsel before the decision was made by the court had no effect on the jury's verdict and therefore is harmless. The jury did not find the defendant guilty because of a determination on his safekeeping was made without a hearing on November 3rd, 2022, and no attorney appeared. Nor did not having an attorney or a hearing at this stage permanently deprive the defendant of an opportunity to raise any claims or assert any defense. And this goes back to what they were saying earlier, that the defense filed 2 motions and presented this issue to the court. So they say clearly the defense did that after the order was entered. The lack of counsel must be complete to apply the presumption of prejudice. The presumption of prejudice applies only when the error infects the entire trial process and necessarily renders it fundamentally unfair. Now, we do know that the defense, they made this argument. They extended this, whether the court's going to find that it can sort of flow that way and this error can fully carry over to the inability to the unfairness of the trial, to the admission of certain phone calls, to the admissions of so-called confessions. We'll have to see, but I do know the defense is arguing that that's not something that is coming into play here. You are just, once you find it's a critical stage, you got to undo it. The lack of counsel must be complete to apply. Sorry, I said that. Okay. The presumption of prejudice only applies when the error infects the entire trial proceedings and necessarily renders it fundamentally unfair. The chronic exception is narrow and is only applied in the case of non-representation throughout the entire case. See how they had to cite to a Seventh Circuit case there. If that's application of federal law, you still have the Indiana Constitution, and we have gone through the defense pleadings and heard from Michael on this issue, and in his personal experience, they have applied that even to a sentencing hearing or other proceedings, and it is not something that it has to be non-representation throughout the entire case. And I think that is also through the application of the Indiana state constitution. Due process under the 14th Amendment as it pertains to Brad Weber testimony. The defense argues that the defendant's due process rights under the 14th Amendment of the United States Constitution were violated because the state presented testimony that Brad Weber arrived home in a white van around 2:30 p.m., knowing that the testimony was false before it was elicited or failing to correct it once it had been elicited. The defense cites a video located in discovery from the residence near the Monon High Bridge, a video that was included in the discovery, turned over to the defense, and that the defense had the entire time of trial. That the exhibit presented by the defense is in the form of a YouTube link that is not identified as any item of evidence by an Indiana state police number and is therefore an improper submission for consideration by the court. It is unverified by legitimate means as to date and time. So let's take the first part of this, that they're saying that this is a YouTube link and there's no way to tie it to the discovery tendered by the state. There is an affidavit here. So unless the state is presenting an affidavit, a counter affidavit that says we didn't produce it like that, that's not anything that we have, that's not anything we produced, then they're stuck with what the defense said. And clearly they're not saying that because it is what they produced. Um, for sure. So now let's look at the second part of this, which is something that we all identified as an issue when we read the state's motion. It is unverified by legitimate means as to date and time. Defense allege that the time in the video is off by 12 hours without any proof of said allegation, except their apparent ability to tell the time by simply looking at the daylight and moonlight in the video. They further make assumptions about the content of the video. Okay, so there's no affidavit here again, no counter affidavit that says that's not what I see. I looked at this and what the state is saying is in there is not in there. It's not an assumption when it's a sworn affidavit about what is in there. And they don't expound on this. But the state goes on to say they present zero evidence in support of said allegations. I I I say they did present evidence. We went through it, and again, there was an affidavit um, supporting it. That the simple answer is that the motion to correct error only applies to newly discovered evidence. From the defense's own admissions, this is not newly discovered evidence, but rather they had been provided long before trial. The defense chose not to present it as a part of their trial strategy. Now, there's an assumption because from another interpretation of what the state filed is that it was amongst the weeds of things that they sent us, and we had no reason to know that it was going to be a point of contention until it came to trial. So, and it's hidden back there. I mean, like who's going to see it? So, I, I do think I did read some case law, and I do think that um, obviously we pointed out before this whole newly discovered evidence is the biggest hurdle, here, and whether things were a surprise or they didn't know to look for it, or it's hidden, in something that's not readily available. There's stuff there that the defense can use. Whether it's going to be enough, we'll have to see, and it's not going to be something we'll know from this judge's ruling. We'll know it from the higher court's ruling. But I did read cases where they're talking about motions to correct error and not violations, where the state intentionally knowingly introduces perjured, false, fabricated testimony or evidence, which is the allegation here. It's one of the most serious allegations that can be made. And for them not to say it's not accurate, but they had it already, that's some bullshit. And I don't, I'll be interested to see how the courts rule on this, and if they're going to say that the fact that something existed in discovery, but its relevance was unknown, or it's hidden back there. The state knew it was there. The state doesn't say they didn't know it was there in here, that this was equally a surprise to them when the defense spotted that car, hidden in the back of that video footage. All right. So in any event, they go on to say the defense chose not to present it at trial as part of their trial strategy. Uh, no affidavit, even to support that allegation. It was a trial strategy by experienced defense trial attorneys. Therefore, it is a moot issue because it is not newly discovered evidence. At best, this is impeachable evidence that the defense could have used when Brad Weber was on the stand testifying. Evidence which is merely impeaching is not available as grounds for a new trial under the rules concerning newly discovered evidence. I would not find this to be just a matter of impeaching evidence. This is it completely contradicts what the state presented. It also impeaches him, but it also establishes that the state put on false and misleading, whether it's false, misleading, perjured, whatever the case may be, the state knowingly misled the jury. And they have not from we'll keep going, but I don't think that they established they did not do that. Evidence which is merely impeaching is not available as grounds for a new trial under the rules concerning newly discovered evidence. Further evidence must be more than impeachable or cumulative, must not be reasonable, discoverable. I think that should be reasonably discoverable before trial, and also evidence that would probably result in a different verdict. And they cite some Indiana cases there. It must be more than contradictory, citing another Indiana case. Finally, the testimony by Brad Weber was not the exclusive evidence the state used to convict Richard Allen. Brad Weber was put on the stand multiple times. The defense had every opportunity to cross-examine him. If anything, this evidence is no more than impeachment evidence that the defense chose not to use. The defense is not permitted to request a new trial to change strategy when their chosen path fails. Again, no citation. This also applies to any phone. Sorry, something banged on top of me, frightened me. This also applies to any phone pings that were in discovery for Brad Weber. This is not newly discovered evidence, the defense's own admissions. Further, at best, it's impeachable evidence that the defense chose not to use at trial. So again, the pings, I don't think that those need to be newly discovered. I think it's just evidence that abuts the defense's position, that is connected to this newly discovered evidence to show that it is what it says it is. And as the state pointed out, they're just making up a time was their position. This also supports that that time is not, they didn't just pull that time out, and it's supported that it's 12 hours off. And I think that um that this was raised when we discussed the state's motion initially, and I believe Michael said, at a hearing they'd be able to provide some additional foundation for the time of that, the timing of that video. Now they turn to Ricky Davis' claim of confession by Ron Logan. That the defense next argue that Richie Davis claims that Ron Logan made a confession to him, said claim being newly discovered evidence entitling the defendant to a new trial. That any information pertaining to Ron Logan falls under the state's motion in limine concerning third-party motive. The defense had 3 days to present evidence to meet their burden for third-party motive. They mentioned Ron Logan, but failed to meet their burden with the court. They chose not to present this evidence in that hearing. That's an issue. That is an issue. And that might be something raised as ineffective assistance of counsel later. Now, maybe they file counter affidavits to this, establishing that, again, it was, mixed into a bunch of other discovery that was tendered. And at that point, they had, no reason to be looking at Ron Logan because they had been excluded. I don't know. They also did not present this evidence when they renewed their motion during trial. Again, an issue. This now seems to be an effort by the defense to use a motion to correct errors in an effort to circumvent their burden concerning third party motive. I don't know what they're talking about. That this is not to circumvent their burden. This would be to establish that it could have been reached with this evidence. Um, that this evidence, along with the video surveillance evidence from the residence, was received by the defense on January 30th, 2024. January 30th, 2024. I mean, why in the hell is it taking that long for them to get evidence in the first place? As evidenced by the discovery release herein attached to State's Exhibit 7, and we'll get to that. Hi, babe. That the defense team, consisting of 3 experienced defense trial attorneys, made a choice not to fully explore or present the Richie Davis claims, which the defense admits was contained in discovery. That the alleged confession was made to an inmate at the Department of Corrections named Richie Davis, who is serving 50 years for dealing methamphetamine. That law enforcement interviewed Richie Davis and submitted him to a polygraph at his request. That Mr. Davis failed the polygraph miserably. That Mr. Davis gave a statement that alleged Ron Logan confessed to him that he killed the older girl first and then took the younger one away from the scene, that he killed the second victim later and then brought her back to the scene, that he went back to the scene after search parties searched his property and moved the girls to another location, that he removed the cell phone battery from the girl's phone and left the phone behind, and that he took the girl's clothing from the scene and burned it. Many of these details are directly contradicted by the evidence. The others have no evidentiary support. So here's the state taking issue with a confession that is contradicted by the evidence. Wow, it's rich. That's rich. That even with the alleged information from Ron Logan about the box cutter, there would not have been enough to establish probable cause to arrest Ron Logan. Bullshit. Bullshit. No evidence places him at the scene of the murders, unlike the defendant who left an unspent round at the scene that was subsequently matched to a gun that he owned. Bullshit, quadruple bullshit. That he himself asserted was never in anyone else's possession, who put himself on the bridge at the time of the abduction and wore the same clothing as Bridge Guy. Again, he did not put himself on the bridge at the same time of the abduction. And I still don't know if he's wearing the same clothing as Bridge Guy. I mean, they just keep repeating bullshit despite the fact that it's bullshit. We don't know the time. He gave a range. Stacey Eldridge expert opinion. That the defense finally alleges that an affidavit by Stacey Eldridge supports that dirt or water did not cause damage in an auxiliary jack in order to log wired headphones were plugged in and unplugged. They allege that this is newly discovered evidence that would probably produce a different result at the time at a new trial. And you see, I even had to laugh when we say that that's newly discovered evidence. But that Stacey Eldridge testified at trial for the defense that she did not submit any report, log, or any other information that supported her position that the log accurately supports the headphones were plugged into and later unplugged from the auxiliary jack. But it's in the state's reports. So I don't know what the state's point is there. That this opinion was only supported by her testimony at trial. No. And the actual extraction report created by state's witnesses. That this opinion was only supported by her trial testimony. That prior to her trial, Stacey Eldridge had only done one other forensic phone analysis and had only testified one time prior about a forensic phone analysis. I don't know about that. Is that right? Yes, bullshit is a legal term. I learned it from my esteemed father-in-law. Wish Bob was here because he can say bullshit exactly like his dad. Um, However, he would never say that in court. Um, so, you know. Anyway, so Bob's just watching us, but he can't hear us. That Stacey Eldridge only gained the education to be able to testify to forensic phone analysis as recently as 2023, that the bulk of her expertise is in computer and network forensics, not cell phone forensics. And they put forward her CV, that the state called Sergeant Christopher Cecile, I forget, on rebuttal to testify about headphones in an auxiliary jack of the phone. That sergeant was able to observe photos of the phone when it was found, here and attached as exhibits 9, 10, and 11. That Sergeant Christopher Cecil did testify that one plausible explanation for log entry is that there was dirt or water in the jack that caused a malfunction. This is in part based on the condition that the phone was found in, how long it was outside before it was found, and his knowledge and experience as a forensic phone examiner. Okay, bullshit. Was based on none of that, not even in part, not even at all. No. And again, this goes to extending newly discovered beyond what the courts may the analysis the courts typically give. Here you had complete surprise testimony. The judge let something in that should have never been let in. I don't care if it's error on the part of the judge, ineffective assistance of counsel. Either way, it was a fundamental error, without a doubt, a fundamental error. And the defense was not prepared, nor was their expert to just, not all your typical expert's not going to just hop on the stand and be like, that thing that you just threw out there that I've never heard before, that I haven't had a time to test, analyze, or research is bullshit. The expert's not going to do that. They needed time. So I do think that this is one of those situations. As much as I you know, said I laugh that this is newly discovered, in a sense, I do think that the current analysis of newly discovered would extend in this situation where this defense had no ability to combat it. Should they have asked for continuance? Is that ineffective assistance of counsel? Maybe, but at the end of the day, the judge shouldn't have let that evidence in no matter what. And it's still such a huge error that, the court might not just say, I'm not considering this because the defense didn't object. The defense didn't ask for time. The defense didn't do X, Y, or Z. They didn't make a motion for a mistrial afterwards. They didn't seek to strike it from the record afterwards. So moving on, that this is also based on the facts found through the investigation, including that the phone did not move after 2:32 p.m. on February 3rd, 2017, that there were no headphones found with the bodies. That is the stupidest thing I have ever heard. I am sorry. That has no bearing on this. It shouldn't be in here. It's a ridiculous argument. And anyone who thinks that the fact that there were no headphones found near the bodies is somehow proving, supporting, suggesting, implying, or inferring anything is just full of shit. So, I mean, if the headphones are something that are being used by the kidnappers and killers, why would they leave that at the scene? I mean, it's a ridiculous argument. The state goes on to say that it is unlikely that someone returned to the crime scene after 2:32 p.m. Really? Why is it unlikely? How is it unlikely? What in the hell support do you have for that statement? I believe that there were some videos of people coming, somehow being around the general area afterwards. So I don't know what that's about. But the state says it's unlikely. It's unlikely. Someone returned to the scene after 2:32 p.m., removed the phone from underneath the body of Abby, plugged headphones into the phone, and then kept those headphones in for 5 hours, unplugged them, and then put the phone back underneath the body, all while not moving the phone. I'm sorry, that is literally the most ridiculous sentence I've ever read. It's relying on their facts as though that is fact, even though we know that this timeline that they're putting forward is complete crap. Why wouldn't the water have logged the headphones after the phone was supposedly subjected to this water and dirt? I mean, their argument counters their own argument. What in the hell if the phone didn't move after 2:32, where did this additional water come from? Where did this additional dirt come from? You know, it's disingenuous. Okay? So, that the defense expert Stacey Eldridge sat in the courtroom during Sergeant Cecil's testimony, and the defense had an opportunity to recall her as a witness to rebut Sergeant Cecil's testimony, but chose not to. Now, I addressed that a moment ago when I said she didn't have time to do all the research necessary to rebut that at that point in time. But I'll tell you, I was over there calling Bob on the phone saying, "Please tell me somebody objected, asked for a continuance or a mistrial, something. Like, you get this kind of testimony, you need time to rebut it." Um, and I don't think that happened. So that's definitely an issue as far as ineffective assistance of counsel. But still, I do think it's possible that the courts could say like, this is still considering the other facts, and the state put this in, it should have never got it in. It's like literally not even science, that it's not gonna fall on the failure to object when it comes down to the ultimate appeal. Um, that there is nothing in the logs, reports, or extractions that would indicate whether or not the phone had some kind of water damage, because that kind of damage is not registered in the logs, reports, or extractions of the phone. Where's your affidavit? Where in the hell is your affidavit that there's nothing that could be extracted from the phone? There's no log, there's no nothing that someone could have looked at to determine whether or not there was water damage. Where's your affidavit by the guy who examined the phone that says, "I looked at that little, that little hole in the phone that tells you whether there was water damage and it was pink," or at least to say there is no way, there is nothing, because and maybe we're gonna have to go back and look at Stacy's affidavit, but if I remember correctly, she put forth things that would have been um notable that there was some sort of water damage. Where's the affidavit of somebody saying this phone was wet, the phone was dirty, the phone, um, when I picked it up and plugged it in, something dripped out. I mean, there's not even an affidavit of someone saying, "I saw zero evidence of water damage." I mean, I saw evidence of water damage to support this. But there is an affidavit of Stacey Eldridge saying that nothing in those reports is indicative of water damage. Um, that there's okay, so he goes on to say whether or not there was water damage can only be determined by physically examining the phone, which Stacey Eldridge did not do. Oh, so it can be determined by physically examining the phone. Where in the hell is your affidavit from the people who physically examined the phone saying there was, in fact, water damage upon the physical examination of the phone? I mean, my response to this would almost be that they presented false evidence because based on this, the state's acknowledging that you can determine whether there was water damage by physically examining the phone. Now, look, I wasn't in the courtroom. I don't know. Did the defense ask questions about that? Did they ask any questions about that? You didn't see any evidence of water damage on the phone. You didn't see any evidence of dirt on the phone. I mean, if they didn't do that, that again, you know, this all might be setting the groundwork for an ineffective assistance of counsel claim. But again, this was surprise testimony, and I know when we did our interviews with the lawyers, um, I think it was Andy who said he didn't think you could really, rest on surprise testimony because you can do depositions, but that wouldn't have helped here, you know? This was like they knew the state knew about this. It was in their extraction report. Bullshit, he's talking about that there was nothing, no support for this position, um, other than her testimony because it's it's supported by their own extraction report. All right. That again, at best, this impeachment evidence that could have been brought out in testimony during trial is an effort to impeach Sergeant Cecil's testimony. This is not newly discovered evidence to warrant overturning the conviction. This might also squarely fall into a NOP violation, a false or perjured or misleading testimony. I don't know. Someone go down there and look at the damn phone and see if it's got that. Can someone remind me what year this phone was? I know one of you out there, uh, one of you out there knows what kind of phone this was. But you can be guaranteed if there was water damage on that phone, there'd be an affidavit attached here. So, and I think it's starting with 2007. They had these indicator windows. Um, it was included on each model. So it's starting 2007, an iPhone 6. So, oh, wait, right. If it was 2007, then. Hmm. So for the iPhone 6, the liquid damage indicator is located inside the SIM card slot. If you need to check for water damage, you eject the SIM tray and look inside the slot. It's a small strip or dot that normally appears white or silver. If it's turned pink or red, all right, I don't know how much time they get to respond to this, but I think it's fair to assume, since the state does not argue that they've got some concrete evidence of water damage, that there is no evidence of water damage. And then if that's the case, now again, now you do have newly discovered evidence of a NOP violation. So, of them presenting misleading, false, perjured testimony that they knew. They knew that that the defense didn't physically examine the phone. They're acknowledging right here, right now, that the only way, at least according to them, the only way to know if there's water damage is if you examine the phone physically. So, knowing that the defense had not, they presented false and misleading evidence and testimony about the possibility that there was water damage on the phone. I was just looking to see if Michael has said anything. All right. So that again, at best, this is impeachment evidence that could have been brought out in testimony during trial in an effort to impeach Sergeant Cecil's testimony. This is not newly discovered evidence to warrant overturning the conviction. I think that it is, and it could be. I think that um, there's some additional legwork that might be warranted here, and I can imagine the defense not wanting, like, oh well, damn, we don't want to risk. We go and look at it, and there's water damage. But I feel pretty secure in saying that because the state's not presenting any evidence, even asserting that there wasn't. That the same analysis that was used in the above evidence concerning Brad Weber and Ron Logan would apply to this evidence as well. It is not newly discovered evidence, but it is impeachment evidence and therefore cannot be the basis for a motion to correct errors. So here there are there. I was trying to find my phone to see if I'm missing. Bob, tell me anything. All right. It sounds like we're going to get Osbrook here soon-ish. So you guys note your questions now for when we get them on here. And all right. So this was that initial hearing on the 28th. And at the point of this was, again, that the defendant was advised of his right to counsel, of his constitutional statutory rights charged against him, and the possible penalties. Defendant advised the court he intends to hire private counsel. Defendant is advised he must retain that counsel within 20 days. All right, so the next. Oh, there he is. All right. Hey, Michael, can you hear me? Oh, we can't hear him yet.
Hi there, I can't hear anything. Maybe you can hear me.
Now I can. Can you hear me? You're getting no sound on your end?
Hang on.
Hang on, people. Technical difficulties. Can you hear me now, Michael?
I can hear you now.
All right, I can hear you. Before we keep going through these exhibits, why don't you tell us what you're thinking as far as that the state's response?
I think the two big things that leapt out at me were, there were a bunch of things, but the two big things were the failure to answer the NAFTA claim, and I really think the state's response on chronic is, at least the law of chronic, is wrong. I think there is a huge argument to be had about, whether safekeeping hearings a critical stage. They pulled out, and I haven't actually seen the response, and I don't know where Nick McClellan got the glosses that he used for what constitutes a critical stage, but they're accurate from this case or that. The gloss I chose was from Cone v. Bell, which was friendlier to us because it's a stage that has significant consequences for the accused. I have some lower court cases about bail hearings in various contexts being critical stages. So that's conditions of confinement, and safekeeping would seem to fit
Follow that.
that. But there's an argument to be had about, whether a safekeeping hearing is a critical stage or not. And
Well,
yeah.
Sorry, I was just gonna say, what about I didn't mean to cut you off. I'll let you finish.
No,
I think
I put up on Twitter. I mean, I think it might have been a 10th Circuit case, but there is no, in a true chronic case where you're deprived of counsel at a critical stage, there is no harmless error analysis. It's end of story. It's prejudice is presumed, and I think the 10th, Andrea, as great as she said, was talking about, presumptions of prejudice can be rebutted, but in fact, the presumption of prejudice in a chronic case is irrebuttable.
right.
It's the courts presume prejudice. It's not there is a presumption of prejudice.
Right. Right. It's you are presuming it, not just a presumption that can be
Yeah.
rebutted. So turning to their factual arguments about Ron Logan and whether that evidence was produced by them, about, for example, what I was just going on a rant about as far as the phone not having water damage. I see a huge issue with their lack of a counter affidavit. Do you?
Well, it's kind of the same problem that they had with Lesenby's motion for, a safekeeping order, and that is it was unverified. I mean, there is literally nothing in front of the court.
Right. But don't you think it's fair to assume that if there was water damage on the phone, they would have included an affidavit that there was water damage on the phone?
Yeah, absolutely. I mean, there are no affidavits with this response. I mean, there's literally no countervailing evidence. And this is what Nick McClelland has done over and over and over again in front of Gull, and that is he just pitches these things up, makes factual assertions, and as if because he said it, that's evidence. I mean, he talks about people being cleared. Well, there's no evidence of people being cleared. It's just you saying so.
All right, and there's no affidavit, which is required. You cannot just say things in countering a motion to correct errors without an affidavit, right? Unless it's in the record, I would
Well,
assume.
in general, you can't if you're making factual assertions to the court. You can, as a lawyer, you can verify, that is to say, sign your motion under penalty for perjury. So there are at least some things of which you have personal knowledge. You can, in essence, in the motion, testify to.
Right. But you do that by way of either an affidavit or a verified pleading, which this is not verified.
Right.
So
No, it's really sort of lawyer 101, and I just don't understand it. He does it repeatedly. He's done it over the course of the year that I've been looking at this. He just does it repeatedly.
might the defense file a motion for to have to view the physical phone and supplement this motion, and might that extend to an additional argument? Now I'm saying nop. I think you're saying, how are you pronouncing it? Not nap or nop, but
Napoli. Some people say Napu. I say Napui.
Okay.
I think Andrea says Napui as well, but some people just say Napu. It's Napue.
Right. Napoli. So to make a Napoli argument, or at least the argument that they misled the defense, because the jury, because in that situation they know, at least if you take what they wrote in their motion, They are claiming the only way to know whether there was water damage was by physical inspection, that the defense never physically inspected. So they would know at the time they proffered this water damage theory that the defense lacked the evidence that contradicted that.
Well, I mean, Cecil didn't say anything about having inspected the phone for water damage, and you know, I I really liked when you were getting a little unhinged about the factual assertions related to the phone and the headphones, basically, where Nick McClelland is simply assuming that all of the state's facts are true,
Right.
which make and which makes any counter factual assertion ridiculous. And I do know that he said in one of his interviews, at least let me put it this way, I think I didn't listen to the whole thing, but the part I heard, I think I heard him say, you know, we thought that headphone stuff was so crazy we didn't think they were going to use it. And that's why Cecil had to go do the Google search, because they weren't prepared for it.
Right. Right. So
And in this business, I mean, the data is the data. If they want to put on an expert to say the data doesn't mean that, they're free to do that. That's and you know, all of these things. You know, let's have a hearing on the on the van video. I guarantee you, Nick McClelland will be sorry about that.
right. Well, he did not proffer a counter affidavit. There are definitely facts that were alleged in there. And I do think, do you think the fact that that white vehicle, the white van, is concealed? Now, wait, before I go there, did you guys make the argument in your motion that, and I think you did, that the state was aware of the video showing that the time was wrong? You did make that assertion, because that was the whole NAPU
Yeah,
argument.
it is that they knew that Weber's live testimony was false, and I'm with you. He says it's, you know,
Oh,
Nick McClelland says that the at best the Weber van video is impeaching, and that is not true. It is substantive evidence that
yeah,
of when the van arrived. It is not just. It's not just what the so if if they'd actually been able to impeach Weber with Poll's testimony, um, the jury would have had to choose between which thing. I mean, that would have been merely impeaching. The jury gets to choose between which thing Weber said is true or whether any of it's true. It's about Weber's credibility. The video is not about Weber's credibility. It is about when the van arrived.
right, right. And again, the state did not put in a counter affidavit that they were unaware of that van traveling at that time, or that they made some determination that it was not the van. They just say that without affidavit that it's an assumption by the defense. And am I accurate in saying, for the purposes of determining whether there would be a hearing, the court must accept the verified facts, the affidavit, facts contained in affidavit, as true when the state does not present a counter affidavit?
Pretty much. I mean, you know, the lawyers asked for a hearing. I mean, you know, I,
When do they have to have the reply on file?
there is no provision for a reply.
What? You're not, as a matter of course, the moving party doesn't get to reply?
There's nothing in the rule. There's nothing in the rule forbidding it, but there's only a time limit. I believe. I think, you know, Kara was in the chat. I don't believe there's any. So I don't believe there's any provision for a reply.
Kara, if you're in there, let us know. Can the defense reply? It seems it could be beneficial to reply, especially if the So you're not envisioning any set of circumstances where the defense will attempt to look at that phone to determine whether there was water damage. Because it doesn't take an expert to look at it. It just takes someone to take that SIM card out. Because I do think that could be I'm trying to say it the way you do, NAPU argument, for the reasons that I mentioned earlier, that they say right here now that the only way, whether that's right or wrong, they claim it's the only way, and they knew the defense didn't do it. So they knew the defense was missing that evidence that was necessary to contradict their entire theory of how, of that it's not somebody putting headphones in, that it wasn't manipulated by human hands after the fact.
Yeah, it's a little that's a little complicated. I mean, I think what I understand you to say is, I mean, they didn't examine it either, I don't think,
Oh, of
because,
course they did. That's ridiculous.
well, I mean, not for water damage.
I don't believe that for a moment.
Well, Cecil wouldn't have to have been. I mean, there's nothing in any of the reports about water damage, or that they even examined it for water damage. I Yeah, I don't know.
Well, but they would have taken the I think they would have had to take the SIM card out as part of their examination. I don't know. I think that's I'd have to look back at what the instructions are for forensic examination before you connect it, and it it could be run with a SIM card or without a SIM card. They say you got to turn off the phone and then do this and then do that. I think that it is
Yeah.
a foregone conclusion that whoever did that extraction, or searched the phone, looked at where the SIM card is. And as we both know, whether they put it in a report and the prosecution's fully aware of it, doesn't matter. If the cops left it out on purpose, which it seems obvious that they did, because I'd almost say that you want to see one other of their, extraction reports and reports on a phone forensic examination of an older phone that has those SIM cards, to see if that's in the normal course. It would mention the fact that they they took out the SIM card or looked at that area.
Yeah, I
But
don't know. I really haven't drilled down on the thing about countering Stacey Eldridge's affidavit, sort of trying to undermine her credibility again without an affidavit when she was a qualified expert at trial. I don't get that.
right, and it's in
But
their reports. That's in, like, what they say, that
but
she was able to make that determination.
but there was a factual thing in the response that I find a real head scratcher, and that is, again, I haven't seen it, but I've heard it read. Something about taking a battery out.
In the response?
Yeah.
Let me see. There might have been. I think I remember seeing that. It says here. Oh, wait, no, that's Ron Logan. And it's the only time battery is in here. So
And what does it say about the battery?
As they're talking about Richie Davis's statement of Ron Logan's confession, that Mr. Davis gave a statement that alleged Ron Logan confessed to him that he killed the older girl first and then took the younger one away from the scene, that he did that to the second victim later and then brought her back to the scene, that he went back to the scene after search parties searched his property and moved the girls from one location to another, that he removed the cell phone battery from the girl's phone and left the phone behind, and he took the girl's clothing from the scene. Many of these details are directly controverted by the evidence. Now, again,
Okay.
no
Okay.
affidavit saying the cell phone battery was in the phone when they had it.
Well, yeah, but iPhones, you can't just take the battery out, and more importantly, at least from the thing, there is nothing in the exhibits related to Reese Davis that were submitted with the motion to correct error that say anything about a battery being taken out of a phone. And Nick McClelland is now revealing facts about statements of Reese Davis's the defense may have not known about.
I was wondering the same thing. I was thinking that when I was reading, I was like, this seems to have a lot more facts than what we were told. By the way, I checked real quick, and you can remove the battery from an iPhone 6, but it's not designed to be easily removed by an average user. So, but if there is no battery, if there was no battery in the phone, that would have been interesting based on this. But yeah, so these are new facts that you were unaware that Richie allegedly said about Ron Logan's confession.
Well, it's not in anything that was submitted with the motion to correct error. Is all I can.
Right. And did he fail a polygraph miserably? If you know.
I'm sorry. What?
Did he fail a polygraph miserably?
No idea.
And there's, again, no affidavit, even from the officer saying, I reviewed the reports and he failed the polygraph miserably, which it's neither here nor there whether he did. But again, it's facts. He's putting in facts without any affidavit.
Well, and the polygraph evidence wouldn't come in. And the question is not whether any judge thinks he's credible. The claim is based on whether the jury should have been given
to consider it.
Yeah, and they can judge the credibility. And McClelland would not be able to get up in front of a jury and say, and he failed a polygraph miserably.
Right. Even if he had.
Yeah.
Or couldn't put on evidence of any polygraph.
No.
Period.
And look, yeah, it's a jailhouse confession. Prosecutors use jailhouse confessions all the time.
There is some moisture, it appears, on the face of the phone in these photographs.
Well, and that's an interesting question. Those seem to have been trial exhibits. I find it very interesting that McClelland would not file those exhibits confidentially since they were ordered sealed.
Right.
I'm sorry, but it's, to me, I mean, people make mistakes, don't get me wrong, but this is, unverified, no counter affidavits. You file these exhibits that have been ordered sealed out in the open. It just,
yeah,
I don't know.
No, agreed. And obviously this moisture is moisture that occurred over the time the phone is there for days and the weather's changing, and would more likely support if water damage happened, that it would have happened well later than when they're saying. But I can't tell. I mean, it could just be dirt, but it looks
well, and
actually I mean, might not be water.
Nobody's ever seen these, and what I want to know, I mean, it's always been described as the phone, and I always heard it as inside a shoe under the body, and I want to know if that's true, and that could be wrong.
But when I was in the courtroom and they showed them rolling the body, it did not appear to be inside the shoe, but sort of under the shoe, sort of. Like the
Okay. Well,
shoe was kind of on top of it.
so, but my question is then, how does the phone get under the leaves?
Yeah. And without having those pictures to look at again, because it looked like it was more like on the side, kind of like not fully under. I don't know. I can't remember anymore seeing them in a flash minute, you know. Um, but yeah, 11 is like fully, almost fully covered. And it looks
Yeah.
like the
I
phone
mean, I don't know. Look, this is the first time
changes.
anybody's seeing these. I haven't seen the other pictures. One of the things, one of the things I'm pretty good at is looking at crime scene photos and seeing things. I don't have enough here to come up with anything, but
Right.
it just given the descriptions over time, this just doesn't
It
seem to fit
appears
those.
to me like the shape of like the phone is changing shape and where the leaves are as
Yeah,
in each of these
who's
pictures.
moving the leaves?
Um,
Oh no, I've got a case, an old murder case out of Gary, where you look at the crime scene photos and it's like stuff's been moved, folks.
yeah. And I take it back that, there's no way for me to tell that if that's water damage from that. That could just be dirt.
Well, it could be condensation, but
It could be, but now that I'm getting closer, I can't tell for sure actually, because it
but
seems textured.
so I think the only thing that Cecil said from his Google search was that water or dirt could have caused the behavior. I don't think he said it did.
Right,
And but Stacey Eldridge's affidavit says, yeah, no, it can't.
right,
I mean, that's really the bottom line.
right, and they don't put forth an affidavit that says, again, that it actually can based on any actual real, uh science, or to say that there's something more that supports it. That's the other thing he does in this. He says in here that that the testimony is supported um, by his forensic experience, and no, absolutely not. And where's the affidavit to say that? Um, Not only isn't it what he said, you still didn't put forth an affidavit to support that. That somehow his experience supports that. Like they're like, yeah, that makes sense to me based on all my experience because of X, Y, or Z. Um, do you know what time the hearing was, as far as the email on the November
I don't.
3rd?
I don't know what time the hearing was. I want to say it was 9 a.m., but it might have been 10, so it might have been after the email. I have no idea.
Right. Here's
Um,
the
but it would be, it shouldn't be a hard fact to find out. It should be on the court's calendar for then.
right.
Um, the more interesting thing for me is what prompted that email from Brett Gibson on the 3rd of
Right.
November.
I was thinking the
And,
same thing.
and well, you and Kara are always way ahead of me, so I really just need to get off.
Why? Where's Kara on this?
She's down. She was down in the chat.
Oh,
Um. No. Like, what were all the communications? This is why we have hearings. I mean, this is and Gull can stamp denied on this. She does. And she can decide as a matter of. She gets to decide the law on this. I mean, there are no cases on whether safekeeping hearings are critical stages. She can say, denied, not a critical stage.
right.
And the rest of it doesn't matter.
Well, I'm going to go on record as saying, even if it's not on the basis of the state presenting false or perjured or misleading testimony, that it would still be considered newly discovered, um, if the physical examination showed no water damage because the state knew that the defense hadn't physically examined it, and there was no reason for physical examination before this, last minute Google search testimony about water damage. Although, it also might just go to ineffective assistance of counsel for not looking to see if there's water damage on a phone that the state said went through the water.
Well, and again, this isn't verified. There's no proof that you can only figure that out from.
No, I absolutely agree with that, and I do think, and I don't have it up right now, but I thought that there was some information in Stacy's motion or affidavit that said that there were certain things that you could yeah, I don't have it right here. Correct errors. Yeah, I don't have it right here. But I thought that she pointed to certain things that would have been either a symptom of, I thought that there was stuff that she put forward on that.
Yeah, I haven't looked at the affidavit recently, so I what she said specifically is important. So, and
Right.
the other, so yeah. Yeah, but the battery thing is, factually interesting, and yeah. I don't know. Are there questions in the chat that need to be answered?
I don't know. Mandy, we got anything? I saw, oh wait, she just had one highlighted. Is it odd? And I just clicked off of it. Here we see what again a few hours later in pics because facts are flexible. Right. Let's see. Right. Condensation is not the same. Mandy, if you see any questions before we let Michael go. So you're not anticipating any sort of response by the defense, even case law about the lack of an affidavit and the requirement that there be a hearing because of it, or
I have no idea what they're planning. I haven't been in touch with them except about a few other things unrelated to this. So yeah, I have no idea.
I'm just trying to see if any of my highlights prompt a question, but
I think it's highly likely that tomorrow or the next day there's going to be a stamp denied on the thing, and the 30 days for a notice of appeal starts to run.
Or maybe, I mean, if they decided they wanted to file a motion, I guess they could file a motion for leave to file a response so that the judge, if she were to do that, would have been not giving them time to reply. But
yeah, but the problem with filing a motion for leave to file a response is she can end that just by stamping denied on the motion to correct error, and she doesn't even have to deal with the reply. So
right, but then it might be able to get remanded for, I don't know, on some
well, so Stacy and Mark can certainly ask the Court of Appeals to send it back for a hearing on the motion to correct error.
Right.
We'll see. Who knows? It's. I'm a little surprised. It's the kind of thing. There was enough in that motion to correct error. I mean, a lot of people. Well, I say a lot of people. Some people have been ridiculing it. There's enough in that motion to correct error that if I'd been Nick McClelland, I would
more seriously.
Well, at least in this way, and that is, you have 15 days to reply. If you need more, you can get that extended, I think. And I would at least immediately have been in touch with the AG's office. Like, what have you got on chronic, folks? How would you all? I mean, the deputy attorneys general up there, they're dealing with these kinds of issues all the time.
Right. Right.
Um,
And to not even have counter affidavits of anything. We're going to get to the only counter affidavit that they do have, but it's, nothing that deals with any of the factual issues or factual arguments that the state made in this motion.
and maybe you read it differently, but I don't really think that he answers the box cutter hook on the Reese Davis, that casts, that Core's testimony about the box cutter casts the Reese Davis testimony about the Logan confession in an entirely different light.
No, he totally glosses over it. He says this here, that even with the alleged information from Ron Logan about the box cutter, there would not have been enough to establish probable cause to arrest Ron Logan. No evidence places him at the scene of the murders. Unlike the defendant, who left an unspent round at the scene, that matched a gun that he owned, that he himself said was never in anyone else's possession, who put himself on the bridge at the time of the abduction and wore the same clothing as bridge guy. So he completely and totally doesn't address it, and puts again forth facts that are not an actual fact.
Well, and the thing that he leaves out again, and you're not going to look. You're a trial lawyer. You're not going to put on testimony that isn't helpful to you, right? But the thing that he leaves out is that a month or 6 weeks before this confession, alleged confession to Reese Davis, there was a judicial finding of probable cause for the FBI to search Logan's property.
Right.
If there was probable cause to search his property, you add the confession to that, and I don't know how you don't have probable cause to arrest him.
Me neither. I 100% agree. And especially on this, I mean, he doesn't even put forth any sort of real valid argument. No case law, no, he just literally says there wasn't enough because in his opinion, there was more for Richard Allen, even though he relies on facts that are not established as a matter of fact by evidence. He put
Well, and
himself
we
on the
didn't,
bridge at the time of the abduction. We don't know that he did do that. He
yeah.
gave,
And in the motion to correct error, the word nexus, I think, was pretty intentionally left out. But I would say that if you can establish probable cause to arrest somebody, that's nexus, folks.
right. Right.
It doesn't require DNA, as some judicial officers apparently seem to think.
Well, I appreciate you coming on. I don't see. I see this question start about the search warrant, but I'm not sure how that translates into the response for the motion to correct, unless you see something I don't in that question. Did anyone check the search warrant? It was served at 5 p.m. Judge didn't sign off until 6:37 p.m. But the search warrant's not really at issue in this.
Yeah, that's the search warrant for Rick Allen's house, and yeah, people have raised that timing question, and I don't know the facts, so.
Yep, it's the same.
And God help me for caring about facts, even though some people seem to say I don't.
I mean, people will say just about anything, including Nick McClelland. So
Well, I will say this as the person who literally put together the 16, I think it was, exhibits for the motion to correct error, and say what you will about the motion to correct error, but there is nothing in there that is untrue or misleading.
Right. There's receipts for everything.
And if you want to argue about the time on the video, let's have at it. So yeah. Well, thank you for the opportunity again.
Yep. Thanks for coming on. We appreciate it. We're going to go through the rest of these exhibits and then touch on the NBC's motion. I know when Andy, or was it Brad? I think it was Andy was on when we were interviewing him. He was like, "All right, people, ask for this evidence and go ask for this. You can look at it now. It's a part of the record." Seeing that no, people can't get this stuff. They've been trying. NBC can't get it. I don't know what.
Well, I don't think they should be able to get the video, the bridge video. But I don't think I think the crime scene photos, Judge Gull ordered them sealed. I don't think they get those. Now, I think ordering them sealed was a mistake. I mean, I think it's actually a legal mistake. I kind of get, and I think everybody might get that, seal all the crime scene photos that have body parts in them. But the rest of them, there's no reason they shouldn't be public.
Right. Or even redacted with the somehow shading out the actual body parts, because I know that picture when they started to kind of clear things away from the body, that you could see that phone and that shoe, clearly. And everyone's asking about the warrant. If there was something the defense missed about the search of the home, and the warrant wasn't signed until after they did the search, and that ends up being an issue that the defense never raised, that's something the appellate lawyers will have to
the appellate lawyers, it's not in the record, so the appellate lawyers aren't going to be able to do anything about it.
Well, no search warrants were presented at any point?
They may have been. I mean, yeah, I don't know what's in. Okay, let me qualify that. I don't think there's enough in the record that I know of, and I by no means. I mean, look, havoc has been. Judge Gull wreaked havoc on this record, and if there is something that shows. There's nothing if there's something that shows that the warrant was executed before the warrant was signed, there's still nothing the appellate lawyers are going to do, because it's going to be an ineffective assistance claim.
Yeah, but and you're saying they can't really raise that?
No, not in a direct appeal, not in Indiana.
Okay, so it would be an argument made on a post-conviction petition.
Yeah, and it would be a pretty good ineffective assistance claim, because they moved to suppress it on other grounds. So if they missed,
right, because it would show that they felt strategically there was good reason for it to be excluded, so they couldn't really make a strategical argument for that.
Yeah. So and I don't know. Your audience should understand. I mean, lawyers, especially trial lawyers, are alleged ineffective all the time. It doesn't mean. I mean, people make mistakes, and they make big mistakes, and Lord knows I've made a few, and I'm being I don't think I made a mistake in this case, but I'm being alleged ineffective in a direct appeal that I did right now.
I mean, that's it. That's what we have to raise as lawyers to try and get things in front of a court that we otherwise have no avenue to get it in front of a court. Defense attorneys know that's part of the game. I mean, I'm always like, if you can find something I did, go for it. I'll give you an affidavit that says I didn't do that for strategic purposes. No, 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 I just screwed up. Um, you know, happy to help the defendant if I honestly missed something.
Yeah.
But yeah, that's normal protocol, and one of the exceptions for raising an issue that wasn't otherwise preserved. So you got to at least try. Even, you know, a lot of them get denied, but you got to try. Or then, like you said, you get accused of being ineffective for not raising it yourself.
And somebody on another channel is saying, "Well, they're going to expose me," and they mention a case in the Seventh Circuit where I wasn't the lawyer involved, but I was consulting on the case, and I made an enormous mistake because I did not know that an actual cert petition in a post-conviction case does not stop the statute of limitations running. And the Seventh Circuit, I think, in their opinion, called me out by name 13 times.
Hey, it
and
happens.
and that's
You've been
fine.
exposed, Michael.
Well,
Exposed.
but I want to tell you that the day, it might have been 2 days after, if it wasn't the day after, I took that opinion into my class and said, "I told you everybody makes mistakes."
Right.
and teaching from my mistakes is one of my favorite things, actually.
Yeah. I mean,
And I've made some whoppers.
we all do. It happens.
Um,
As Nick McClellan did here without even putting forward affidavits to support its facts. And
yeah, it's kind of, I don't know. I think it's part of it. It may go with what Lesenby was doing with Diener. It's just like small town stuff. This is just the way we always do it, and it's good enough. 99 days out of 100.
right. Well, this is your 100th day. You're being called to the fire. So, what they get away with every other day, it's not happening today.
And I do read the safekeeping statute as required. I mean, I understand as a practical matter, it may make a lot of sense for one jail to be able to call up another jail and say, "Hey, would you take this person for a while for whatever reason?" But as I read the safekeeping statute, you can't do that.
I mean, right, because the whole point is so that they can't abuse it on any whim that they want to, put forward.
Yeah, yeah. And oh, that's the other thing. Did I already say the other thing that I think I put it in the chat before I got on? But the other thing that McClellan left out in his whole safekeeping recitation was that Rick Allen had an absolute right to refuse the transfer to the DOC.
Right. Which suggests the right to counsel, which suggests a right to a hearing, which suggests all the things that he did not cite case law for saying there's no right to a hearing. If there's no right to a hearing, how does one object before it happens?
The thing to me, so there is actually, and I think the Indiana Supreme Court has read it wrong. There is one case where somebody claimed they had a right to a safekeeping hearing, and the Supreme Court said, no, 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 no. The Section 2 of this says you're entitled to a post-transfer hearing. And the reason I think the Supreme Court's reading that wrong is twofold. First, the purpose of that statute is to point out that a safekeeping order is not the end of the matter, that you can get a hearing afterwards to undo it.
Right.
But the other reason it's wrong is that Section 1 of the safekeeping statute requires a finding by the trial court. How do you do a finding without a hearing?
Right. Yeah, but we both know, right or wrong, whatever the Supreme Court says, that actually is the law, and the court can't say otherwise anyway.
Well, even if let's say you're not entitled, say you're stuck with that as a trial judge. I think there, you know, that you can almost always distinguish cases on the facts,
Right.
as you know,
Right.
and I think maybe this one's distinguishable. But even if you're not entitled to a hearing, the other reason you have to have a hearing is if, under the circumstances that Rick was in, he had a right to refuse. Where does he get to exercise that right to refuse?
Right. Yeah, that's what I was thinking. Like, it's
and,
got to be
and so it has to be at least on paper.
right, which means notice and an opportunity to respond, even if not a hearing.
Yeah, exactly. So
Either
and
way, that brings forward potential due process issues. Even if it's
well,
like you're saying, even if it's not a hearing, he had a right to object, at least on paper, and he was denied that right as well.
so here's why. So it's already set up. It was already set up for the appellate lawyers. The appellate lawyers can absolutely raise Rick's right to be present. But the problem with just the right to be present is that is subject to harmless error analysis. The chronic claim is not. And, that was what was important to get out in the motion to correct error with the evidence to support it.
Right. Right. And hopefully the judge at least acknowledges that they failed to properly, you know, uh, half of what they wrote in there should just be stricken because there's no supporting affidavit.
Well, you want to win as early as possible, but I got to say, whether the safekeeping hearing is a critical stage or not, in the end, would be a really interesting subject for a cert petition to the U.S. Supreme Court.
Right. Yeah, I mean, because this case does have a lot of facts that warrant, looking at it beyond what might otherwise be the typical analysis, because there's just more implications than your standard safekeeping, order. And you've got this question here, Michael, isn't it serious that Nick McClelland knew that Richard Allen had counsel? I mean, the answer to that is yes. It's a huge part of your your first error.
Well, and there's a second part of it too, though, that has to do with the mailing of Rick Allen's request for the appointment of counsel, which, for very mysterious reasons, was returned to the White County Jail and then remailed and didn't make it to the court until the 7th of November. So Rick was already well off to the DOC. But the mailbox rule means that was he formally had a request for counsel on file as of the 1st of November, because that's when the postmark
Right.
on the letter is,
Mailbox.
and that's 2 days before Diener sends him off to the DOC. I think that's a problem.
Yeah. For sure. For sure. Well, we definitely appreciate you coming on, giving us your time and your opinion on all this, considering that you're involved in the the drafting and presenting of all this. So it's been
and exposing myself in public.
no good deed goes unpunished, Michael. You can't count the rantings of lunatics, though. You really can't. I mean,
Okay.
I just it's shocking to me how many people want to claim that either what we're saying or you're saying or another lawyer is saying is just ridiculous or wrong when there has not been one other lawyer. All the lawyers are saying the exact same thing. Every one of us, no matter where you look. I mean, it's just it across the board, everybody is having the same issues, saying the same things, except the people who you're probably taking to heart their comments. So yeah, don't the rantings of lunatics.
No, but I do kind of draw the line, and I do draw the line. It upsets me generally. I mean, not personally, but generally, the people who say, defense lawyers in particular, but lawyers, but mostly defense lawyers in this context. And it's a quote, lie over and over. And I put up on Twitter. I mean, there's nothing that except for having sex with or stealing from your client. Nothing will get you disbarred faster than lying to a court.
Right.
And lawyers do not lie, and it's just some do occasionally, but to assume that the lawyers are lying is just
absurd.
Well, it's worse than absurd because it means that it's a way for people to think of defense lawyers as bad people, but it's also a way for people not to take the argument seriously. And it's too bad, because if people took this seriously, they'd have to see this as almost certainly a wrongful conviction. And if people spend as much time denigrating, spent the time they do denigrating people instead, trying to work out what really happened, crowdsourcing this actually might come up with what happened.
Right. Yeah.
So.
All right.
Okay.
Well,
Thank you.
Try not to take too much to heart. And thanks again. Greatly appreciate it. And we'll talk to you soon.
Well, I appreciate all that you all do too. So thanks.
Thanks, Michael. Talk to you soon. Bye. All right, guys. So here is the email. And again, it's at 9:58. So I don't know if someone can see the docket as to when this matter was set to be heard. But he says, at this point, I do not believe I will be hired to represent Richard Allen going forward. I take that to mean like in the entire case. I want to send him a letter of disengagement so there is no confusion. Can you confirm with me where he is so I can send him a disengagement letter? I also wonder if he's just trying to find out where the hell his client is. And if he did that under the guise of, I'm going to send him a disengagement letter, who knows? But Michael raises an interesting question. Why, what prompted that? Then this is just the court order, which is dated November 3rd, 2022. We don't know the date that it was entered. And I don't think there's much point in reading it. It's been something that's been of issue before, and the parts of it that the state were relying on were cited in the body of the motion itself. So here is the only affidavit they have attached. These are the only facts the state has properly put forward to counter the defense's motion. Everything else McClelland said is bullshit. It doesn't count. It wasn't written. You can just erase it all, line through it all. It should not be considered unless, of course, there was a citation to the actual record. But it says, I currently am employed with the County Sheriff. In October of 2022, I was the Carroll County Sheriff. The defendant was arrested on October 26th, held in county jail until the initial hearing, October 28th, which time he was transported to the Carroll County Circuit Court for hearing. That afterwards, the defendant was moved to the White County Jail due to overcrowding, not pursuant to a safekeeping order. That on November 2nd, 2022, I filed a request by the Sheriff of Carroll County, Indiana, to transfer inmate from the custody of the sheriff to the custody of the Indiana Department of Corrections in compliance with, and he cites the Indiana statute. That in my motion, I cite the reason for safekeeping is due to the safety and security of the defendant and to protect the jail staff and other officers handling the defendant due to the extensive coverage of the case by an array of media platforms. So where is the rest of that to say why the extensive coverage of the case by an array of various media platforms put the safety and security of the defendant and the jail staff and other inmates at issue? Where is the rest of that sentence? That the court at no time gave me legal advice on the motion pertaining to the safekeeping. So it doesn't say the court didn't draft it, the court didn't help me draft it, that he didn't give him advice even. It specifically says the court at no time gave me legal advice on the motion pertaining to safekeeping. The choice of words is not a mistake here. There was no attorney listed of record for the defendant when I filed my motion. Again, it doesn't say, and I had no reason to believe that he was represented by counsel. Doesn't say that. That it is my belief that the motion for safekeeping was in the best interest of the defendant and everyone involved to protect the defendant and everyone else involved in the case. That's it. That's it. That's their facts, contradicting all of the facts that were presented in the defense's motion. Then they put forth the order of judgment, which is dated July 19th, 2023, indicating that he's at Westville under safekeeping order. The court finds the defendant is awaiting trial and is in imminent danger of serious bodily injury or death, or represents a substantial threat to the safety of others. You know, she's citing back to the November 3rd order, which with no reason. The evidence presented at the hearing on the motion to reconsider did not support many of the allegations advanced by defense counsel. In fact, the evidence presented demonstrates defendant is treated more favorably than other inmates housed at the Westville County Correctional Facility. So in light of that, she finds it reasonable, the safekeeping order, and believes that the Department of Correction has and will continue to provide necessary medical services, including mental health services. We saw how well that worked out. If the Department of Correction believes a facility other than Westville is more appropriate, more convenient for counsel, the court is confident. The court's confident the Department of Corrections will move the defendant accordingly. Now, here is, and this is something new. At least I've never seen it before. This is a discovery letter that went with discovery to the defense. And this is January 23rd, I think, of 2023, or January 30th. Received January 30th, 24. So a 3.5 inch, 2 terabyte hard drive. And they're listing on there that it has Allen jail calls, inmate phone calls made by Allen while at Carroll County, White County, and Westville. All the phone calls through December 1st of 2023 from Westville. All phone calls too. So I guess that's from when he gets there until that date. Inmate text or email data related to Allen. Account payment information provided by Westville to GTL, which would be the device they use or whatever for the text and email data. Evidence, Blair Fitbit. I don't know. What's that, guys? Geofences, neighborhood canvas from 2017 and one from 2019. Then they have a filing cabinet scanned, electronic digital copies of filing cabinet paper documents and any data in those files. The files were uploaded and current to this date. Any additional scans will be provided by e-discovery. Holder, 2016 ceremony, actual video from Facebook feed of Odinist ceremony. That's interesting. They're saying, did everybody know this? I didn't know this. That the state's acknowledging that there was a 2016 ceremony of a Facebook feed from an Odinist ceremony. Say what? I thought there was no evidence that these, people were involved in Odinism. You have an interview of Sandra Harrison from 3/14/17 and a phone extraction by the FBI, San Diego, California. This file's too large for successful upload. Photographs, crime scene autopsy, and other follow-up photos. They're just getting crime scene autopsy and other follow-up photos. Some photograph files were too large. Okay, so there's a 3D rendering, commander, state police photos of the crime scene autopsy and other investigative follow-up. As to German, their crime scene photos, ISP photos from 12/7/22. I mean, it's only been a year and a month. So, state police photos of the crime scene and other investigative follow-up by CSI technicians, name and description. Item 101422 SLM, photos of Allen's water bottle in interview room submitted for evidence. So I guess they're getting either his DNA or his fingerprints. Why in the hell does that take that long to get over to the defense? FBI trail cameras. Trail camera photograph taken of the crime scene. All right, so we know that the defense and the state both knew there were trail cameras. Jay Kramer photos, FBI crime scene photographs taken by S.A. Julia Kramer. Police and coroner reports from the Carroll County Sheriff, Indiana State Police, and TIP, DINC 000074. So they sent one tip alone here. Some of these reports contained in the file are also uploaded. The following the e-discovery release, we discovered that some of the files in the Indiana State Police may be incomplete or not populated in Discovery. Therefore, all files in the Indiana State Police were copied to this drive. FBI reports are attached to a separate drive listed below in Discovery Export, and they provide the number. FBI Crisis Management Reporting Software, Orion, is listed on a separate hard drive with the download of 12/7/23. Any additional information contained in Orion will be uploaded. Search warrants, all search warrants and court-related documents. Some files were too large. Thumb drive from Todd Click, which was received on 8/30/2023. All right, so we're getting closer here. August, September, October, November, December, January. That only took 5 months. Westville Prison cell block video, body camera footage during contact with Allen, door sheets, and other Westville IDOC reports and documents. Any problems encountered in playing, please contact, and they say who to contact for their tech team. Another 2 terabyte hard drive labeled pole camera at Mayor's Farm Gate 41017 to 42117. Huh. 1 Western Digital 3.5-inch terabyte labeled, and it gives the number, and that's a pole camera also at Mayor's Farm Gate from 42117 to 427. 1 Western Digital 3.5-inch 500 gigabyte hard drive. They give the label. It's labeled as compilation of data contained on 8110. And it gives some additional identifying numbers. The files on this hard drive contain Delphi flip phone found under the bridge. contained 7226 Delphi flip phone. 17311 Delphi LG phone from found Clinton County Axiom Cellbrite. Huh. I don't know if this means anything to you guys or not, but a white chip off report, Alec Bebot, an Amazon tablet. Oh, this must be an Amazon tablet, pink case found in the woods, German Liberties, Samsung. So they did have a digital image on a hard drive. HEMIG, I don't know, holder screenshots, holder Samsung SGH I337, Jackson Stewartson, Coachert, Liberty, iPhone exam. J. Maxwell, L. Maxwell, McKinney, Pearson SIM card. Just like a bunch of, stuff without explaining what it's for, why it's important. Voorhees, Wallace, Wilbur, Wright, Young, Delphi murders, 2/14/17, Logan, Holder, FTK imager. I don't know about any of this stuff. ISP Peru, 2/25/17, Consec warrant, Liberty German, just like says her name. Magnet, Mobley, persons of interest, Anthony Schatz. So here's their persons of interest. Anthony Schatz, Bob Shoed or Shoed, Brad Holder, Eugene McKinney, Glenn Cunningham, Kevin Stewartson, Larry Wayne Ray, Mike Nipple, Patrick Westfall. Got a tower dump, Verizon tower dump, victims Verizon tower certification, addendum. The original drive was found to contain child sexually explicit material in the Kunsick warrant folder. These files are connected to Keegan Klein's device extractions in relation to his Miami County child exploitation case. The Klein extractions contained on this drive were withheld because they contain CSEM. And that's they can't turn that over, obviously, because then they're turning over explicit material. You have to go in, watch it, it mentions here original hard drive is available for inspection, for full inspection under supervision at our office. That's normal. Another 2 terabyte with photos, security camera footage, photos, Hoosier harvest store footage from the residence of 599 West 252 North, and David McCain's photos from the trail. One 80 gigabyte hard drive labeled. It's a cell phone extractions of Baker, Barger, Circle, Collins, Davids, Eads, Erskine, Germond, Brown, Hart, Henderson, Hicks, Isley, Kullick, Matthews, Marchand. Gives another Samsung. Must be a person who they don't know. Slavins, Toomey, Wallace, White, and Wright. Well, this must be, I'm assuming, all the people who came back on the whatchamacallit, geofencing as being in the area or something. Are these all names that everybody else is familiar with? Should I keep reading this? You guys interested in continuing to hear this? Cell phone extractions from DeMoss, Dylan, Miles, Derek German. Humphreys, Sandifer, Snowberger, and Weber. They had phone extractions from Weber? What? Oh, Lord. More cell phone extractions from an unknown Apple iPhone 5. That's that white chip off the Amazon tablet, Liberty German Samsung, Logan Holder, Jackson, Stewartson, all these people, all these same names that we heard a moment ago. And then also a web trail cam. OS triage. I don't get this. Delphi miscellaneous, Liberty German OS triage. Pictures of evidence in the trail camera. And they use this magnet forensic mobilizer on all of these phones, which includes Weber, B. Weber. So, Brad, because I guess to discern him from his mom. Derek German, and all the other names we mentioned. All right. Then we have phone extractions from 2017 of Bowler, Dunham, Gunther, Heater, Isom, Jester, Myers, Sabella, and 3 unknown devices. What are these things? Where are they coming from? Why are they being extracted? How do you have unknown devices? Wow. You guys want me to keep reading this? There was a pink case found in this. I know. Whose phones are all of these? What is happening? All right, let's go back to it. All right, so phone extractions. These are all the names I just read, including 3 unknown devices. 1 2-terabyte hard drive labeled security camera footage containing security video collected from businesses and residences. Security video of the Hoosier Harvester, the library, the Mexican Grill, the Plaza, the Save-A-Lot. Okay. Another hard drive labeled Delphi DVR Original, containing uncatalogued interviews with Delphi police. Uncatalogued interviews from Delphi Police Department interview room from 2/20/22 to 3/24/22 and 8/17/17. Due to a DVR program error discovered 8/20/17. All recordings up to February 20th were recorded over. There is no detectable audio found on this drive. 4 terabytes labeled Delphi DVR drive, 1 export, uncatalogued interviews from Franklin Street Investigation Center, May 25th of 2018. There's no detectable audio on the original drive from which this duplicate was made. Export 2, uncatalogued interviews again from 2/28/17 to 6/30/17. Delphi Drive 3, containing uncatalogued interviews from Franklin Street from June 11th, 2018. Uncatalogued interviews from also June 11th, same job number 002, but then also 9/1/17 to 1/19/18. Then we've got another hard drive containing security footage from DVR at the Canal Center for April 27th, 2019. 1D12 FBI milestone trail camera footage. So there again, they're disclosing that there was trail camera footage. 1 WD Elements Black Western Digital external USB drive with USB cable. And it's labeled. They were provided by the FBI, containing a zip file discovery export, all FBI Sentinel files and FBI documents 302s. It was also a zip file. Q evidence, digital imaging and video recovery team. Now we've got an extraction. Let's see, 1B70 extraction, comma, 4846 West 37 North, comma, You got another address here, 5601 West 260, brick and mortar, Carroll County Jail, City Hall, courthouse, crime scene cameras, camera 1, 4, and 6, CVS, Danny's Audio Shop. So these are various places they got video from. Here we have again ISP trail cameras, Parsons' apartment or Pearson's apartment. And it says pending collection, Carroll County Courthouse, the Delphi Public Library. Okay, a couple of places. Latest copy of Orion. And that's it. Let me take a pause here to see what do you guys all want to know here? Yeah, there was a Samsung tablet found in the woods. Let's go back. Let's go back. Okay. Because this is kind of crazy stuff. Okay. All right. So a compilation of data contained on 8110, which, let's see, they've already mentioned 8110. Maybe not. Okay. Delphi flip phone. So you've got Delphi flip phone found under the bridge. Okay. And these are like evidence numbers. Delphi LG found phone, Clinton County. Axiom Cellbrite of HTC White chip off report, Alec Bebot, an Amazon tablet, comma, a pink case. It says Kendra Nelson / Woods. German Liberties Samsung. I don't know what this HEMIG is. Holder screenshots. Another Samsung. Liberty iPhone exam. Pearson SIM card. I don't know what this is. Delphi 21417 Logan Holder FTC Imager. Then it lists the persons of interest. Talks about Keegan Klein. Pink case in the woods. So, yeah, I guess the Amazon tablet, I think they mentioned it again. Oh, wait, sorry. Okay. Now, this is a Cellbrite extraction and an Axiom extraction of a tablet. So those are the two places the tablets mentioned. Delphi LG found phone, Clinton County. Amazon tablet. See, there's a comma. Pink case found in the woods. Did that answer everybody's questions on those things? Oh, right here. German Liberty Samsung Galaxy Tab. So, which means tablet. Wonder why they shorten it there. That's it, though. All right. Then it's the curriculum vitae of Stacy. And then there's the pictures of the phone, which I was showing you guys earlier. And I don't know, do we all really think that's necessarily water? I thought it was water at first, and maybe it is, and it just looks different when I zoom in on it because it's getting distorted as I zoom in on it. But, oh, oh, but you can tell in these 3 pictures based on, like, the amount of the phone that you see, where the leaves are from 9 to 10, like, let's see, um I can't rotate it. Won't let me rotate it. No. Um, like, look at the leaves down here and the leaves here, you know? Well, oh, maybe they maybe it's a different angle, but it does look like huh, versus here. And that's definitely different. Like, you can't see any of the bottom like you can here, like the whole corner. All right. So, you guys, I'm just gonna gloss over this NBC thing because that's it. We've been going too long. But they're asking to be heard. They're being denied access um, to records that are supposed to be not under seal. They're only asking for the ones that are not under seal. Um, and then they put through the emails going back and forth where you've got the court. Well, I'll start at the bottom, I guess, instead. So you've got a FOIA request from Justin Balding at Dateline. Any and all recorded police interviews with Richard Allen, video and audio, any and all recorded phone calls between Richard Allen, his wife, and mother. Should have added father there. Um, and it's the requested information is in the public interest, critical to understanding the case against Richard Allen. And they talk about the public access to records, that they've got 7 days to respond. And then it gets sent saying, I guess, see the attached FOIA request text below. On January 8th to Jody Williams. And then Jody Williams says, "Good afternoon. On January 8th, looks like just a couple hours after it was sent, I'm in receipt of your request for release of exhibits. Perhaps at some point in the future, media may be permitted to view the exhibits that are not sealed and confidential pursuant to Indiana rules of public access or court order at a time and date the court determines. But it would be after the filing of the transcript with the Indiana Court of Appeals, as the exhibits are required for that purpose." Um, so then the response, you've got Balding to back to Jody. "Thank you so much for your prompt response. Is there a way to know when the transcript will be filed?" And she responds that same day right away with an entry for a notice of filing transcript will be made on the online docket when available. So then you've got another round of emails, again, starting with Justin to Miss Wilburn on January 24th. And he's asking for the 2 recorded cell phone interviews with Richard Allen, police interviews with Richard Allen, the recorded prison calls between his mom, wife, and mother, and the 43-second cell phone video recorded by Liberty German. And he asks them to specifically indicate what the exemption justifying your refusal, and notes that multiple news agencies have been requesting copies of evidence to date, and to my knowledge, no legal justification has been provided. So that's January 24th at 9:35 to the Carroll County Clerk. And then on January 27th, she responds, Mr. Balding, I have received a request for documents. All documents listed below would have to be requested through Jody Williams, Allen County. These documents may or may not be available. That will be up to the judge. You can reach out to Jody at and that's it. So they're calling bullshit on it, that there's no reason for the judge to deny it. And they say that, unfortunately, it appears that public records may be held indefinitely absent court intervention. The problem is especially acute given that no notice of appeal has been filed at the date of this motion. Granting access to the requested exhibits in this case, which has garnered significant public attention, would promote transparency and trust in the judicial system, cites a case. And I think they also said, right, they're like, they shouldn't be waiting until after they're filed on the appeal. That makes no sense. Exactly what they're saying here. There's no reason that the public trial exhibits can't be copied and provided to NBCU at the same time that the transcript is being prepared. There's absolutely, no right, no reasonable. Like, it's just ridiculous. So we'll see what happens here, whether the judge just denies it. And I would venture to guess that NBC is going to appeal after this if it is denied. They're not going to mess about that. This is ridiculous. All right, guys. That's everything. Thanks, Deja Vu and Brown Eyed Girl, for becoming members. Thanks, Precocent, for your generosity, and Kate Eleanor for your generosity. And hopefully we've sort of answered any questions that you might have from this, learned something new. I don't know, but do me a favor, like, share, get it moving in the algorithm. We appreciate you guys. Thank you, mods. Thank you, Mandy and Tracy, and all you mods out there, for everything that you do always. Thanks to all of our audience. We appreciate you, because without you, I don't know what I would be. I only know what Bob is. So, all right, let's all go eat dinner. Thanks. Bye.